For the record, on the record, let the record show that I, Brent Arthur Wilson, the man, grantor, trustor, settler of the all capitals BRENT-ARTHUR-WILSON trust, do appoint and nominate District Court Judge Deborah Kim Christopher as the trustee for the express revocable all capitals BRENT-ARTHUR-WILSON trust. And I, Brent Arthur the man, is appearing here in this matter as the beneficiary. I repeat that, as the beneficiary of the all caps BRENT-ARTHUR-WILSON trust with the following 3 points of law. Number 1, in construing trusts, unlawful purpose should not be imputed to the settler. Number 2, the purpose for which a trust may be created is the intent and purpose of the settler in truth, which is the law of the trust. And number 3, Brent Arthur Wilson, the man, is not defaulted as the trustee for the all capitals BRENT-ARTHUR-WILSON, having expressed the trust. May I instruct the bailiff to deliver these two instruments?
You may file those instruments if you wish to do so. Mary, if you want to accept those and have those filed on the request of Mr. Wilson. Make sure. I'm not sure. Do you have copies, Mr. Wilson,
Yes,
of those?
set it down there, please.
Do you have copies of those documents, Mr. Wilson?
Do I have copies? No, I wish to have copies of those when you are all said and done with them.
Would you make copies for both Mr. Wilson and for the state?
Yep. And for the record, on the record, let the record show, I hereby instruct and demand the trustee settle and close this case. Will you require a IRS Form 56 notice concerning fiduciary relationship for that?
What I'm asking you to do, Mr. Wilson, is if there's requests that you're making of the court, those need to be made in writing. Then the state has an opportunity to respond to those requests.
Of course.
And then the court will rule on the request if that's within the context of something that I can accomplish. So if you wish to make a request of the court, please reduce it to writing. Have a copy of it served on the prosecutor, and then the court will consider it.
I have it here now for your signature.
I cannot consider any document or any request that you make until the state has a chance to review it and respond to it.
I see.
Upon their review and their response, you have an opportunity then to reply to anything they say, and then the court will consider it.
Are you going to settle and close the case? Go over each? Or go over each?
As I've indicated, if you file your request, the state can review, you can reply, I will consider. But there's a procedure and a timeline for that to happen. So once you filed it, they have 10 days to respond to it, not including weekends, not including the day that it's filed. And then once they file their response, you can reply under the same timeline, then the court will consider it. I will not rule on anything based on an oral motion because that doesn't give the state the opportunity to respond, nor you an opportunity to reply to their response.
Will you require, therefore, a affidavit of surety for this process?
I have nothing before me until and unless you file your request, the state responds, and you reply. So until that's done, there is nothing for me to make a decision on.
Okay, from this position, operating out of a confined jail cell, what is then the next process for that to take place?
Before I guess we get to that, I'm going to go back to something that you and I have discussed before. I remain seriously concerned about you representing yourself. And so in that interest, one of the things I want to instruct you is that there are serious dangers and disadvantages to you continuing in your representation of yourself. You have an absolute right to do so if you choose to. But I want to make you aware that you have to, as I've indicated before, abide by the same rules in court as the lawyers do. And even if you make mistakes, you will be given no special privileges or benefits, and I cannot help you as the judge. The government is represented by a trained and skilled prosecutor who is experienced in criminal law and court procedures. Unlike the prosecutor you face in this case, you will be exposed to the following dangers and disadvantages: of not knowing the complexities of jury selection, of not knowing what constitutes a permissible open statement to the jury, of not knowing what is admissible evidence, of not knowing what is appropriate direct and cross-examination of witnesses, of not knowing what motions you must make and when to make them during the trial to permit you to make post-trial motions and protect your rights on appeal, and of not knowing what constitutes appropriate closing argument to the jury, of not knowing what the applicable rules of evidence are, and of not knowing what the appropriate jury instructions may be. These are some of the areas that the prosecutor has trained in through their law school experience and their experience on the job. I obviously don't know what your background is, but it causes the court great concern if you don't have that legal representative to at least advise you. I have asked before and continue to be willing to appoint the Office of the Public Defender to act as standby counsel, whereby they would give you legal advice which you could choose to follow or not follow. That's your decision. You do have the right to represent yourself, but there are dangers and disadvantages. Do you continue to want to represent yourself, sir?
In what capacity are you addressing that?
As a defendant of a criminal case in this court.
All right. Let me reiterate then, I am appearing here only as the beneficiary to the all capitals BRENT-ARTHUR-WILSON express revocable trust. It is not your fiduciary duty now, appointed as trustee, to handle that matter.
The court cannot accept any responsibilities from the defendant under any circumstances, nor will I make any decisions without a motion being placed before the court that has been provided to the state. You've had an opportunity to reply to, and I had an opportunity to review. I have no such document. Your requests on the record I cannot rule on. You must reduce your motions to writing, provide them to the state, respond if you choose to do so, and allow the court to rule on them. I will not accept any alleged fiduciary responsibility because I am a neutral party designated to sit on this case. I cannot practice law. I cannot accept responsibilities from either party because of my obligations as an elected official. So you need to reduce your motion to writing, and the court will proceed. Today's hearing is on an omnibus hearing, and I intend to go through that process with you, Mr. Wilson, unless you wish to accept the court's offer of standby counsel. Do you wish to accept the court's offer of standby counsel?
No, I do not.
Your Honor,
Yes.
before we go through omnibus, it actually would be the intention of the state to ask for a one-week continuance of the omnibus hearing. Mr. Wilson and I haven't had an opportunity to discuss any possible resolution of these charges, so I would ask for 1 week to accomplish that.
Do you understand what she's asking?
Yes.
Very well. Do you object to having that 1 week, or would you like the opportunity to talk to the state about a resolution of this case?
Is that within the capacity of the beneficiary or the trustee?
Those are terms, sir, that have no place in this courtroom that I'm aware of. Make your motion with regard to it if you wish to do so, and the court will consider it. Your only role at this point is as a defendant on a criminal case. We have a prosecutor and we have a judge. The statements of beneficiary and trustee, without you making some formal motion indicating your legal authority for that position, have no place here. So I am granting the state's request for a continuance of this matter for 1 week to May 27th, 2010 at 9 a.m.
Your Honor, am I not older in